Hello and welcome, I'm Oles Gardyuk and you're watching Head to Head with UATV. The Ministry of Justice of Ukraine has sent a package of documents to the European Court of Human Rights as part of a lawsuit on human rights violations in temporarily occupied Crimea. The consideration of the lawsuit is expected to start in February this year. To talk more about this, we welcome to the studio Professor Borys Babin, Chief Research Consultant at the Institute of Legislation of the Verkhovna Rada of Ukraine. Hello and thank you for joining us today.
Good day.
So, the consideration of the lawsuit is expected to start in February. This is according Ivan Lishchina, Ukraine's commissioner for the ECHR. Do we know the exact date when to wait this court hearing?
There are some hearings and some proceedings in the ECHR devoted to Crimea issues. In the February, the hearings will start devoted to the first application of Ukraine against Russia that cover events from February 2014 till Minsk agreements. And I hope that in this part of sitting, the court will decide to issues of possibility to start this case and define the periods of Russian responsibility for the human rights violation in Crimea, as here we have principal issues, as we insist on positions that Russia make effective control over peninsula from the 12th of February 2014, but Russia say no, we just started to control the Crimea from the March 21, when so-called law on so-called reunion of Russia and Crimea was adopted by the Russian government. That's why I think this is principal issue covering the events of so-called Russian Spring in Crimea, and I know that Ministry of Justice gathered a huge package of proofs that was done since 2014, and in this proceeding, anyway, the result will be important for future issues of the occupation of the Crimea by Ukrainian government.
So this is one of the issues,
Yes.
the spring, this Russian Spring in Crimea.
Russian Spring and all issues of 2014 till the Minsk agreements.
Till the Minsk agreements. This is one of the hearings, as you
Yes,
said.
this is the first hearing. In this hearing, the issues of acceptability and possibility of further proceeding will be solved by court. If it will be solved positively, well, in this issue, I think the half of work is done.
Okay. Can we expect any other court hearings on other cases?
I think they will be later, as we have other huge package of second appeal devoted to issues after Minsk agreements of 2015 and 16 and later. And then we have special claim devoted to the political prisoners given by the Ministry of Justice in 2018. And now we have new claim that is being elaborated by Minister of Justice for current months, devoted to the issues in the Kerch Strait of 25th of November with capture of Ukrainian Navy vessels and Ukrainian seafarers and their illegal being in places of non-freedom in Crimea and Russian Federation till this moment.
As far as I understand, this latest package of documents that was sent to the ECHR was in regard of this case about Ukrainian sailors, right?
Yes, as according to the Rule 39 of European Court proceeding, special measures were asked by government of Ukraine to ensure that the seafarers are in good health status and the relation to them is human. And the European Court demanded from Russia to give the coherent documents to prove they do not violate human rights of those persons.
But speaking of these Ukrainian sailors, they recognized themselves and they declared that they are the prisoners of war. The Ukrainian government also recognized them as prisoners of war. So basically, everyone and all the respectable experts have been reportedly emphasizing that this is breaching Geneva Convention, but Russia seems not to care. And then it goes even further, because according to Russian Constitution, Article 15, any international decree that Russian Federation is one of the signatories of has bigger priority than even the national legislation. So how how can we pressure somehow on Russia that it actually adheres at least to the international law, unless its own constitution?
Some special issues related to exactly this case should be discussed. First, we have three groups of norms of international law that should be implemented to this case. First is the human rights law, including European Convention on Human Rights and others. Second group of norms, international humanitarian law, including Geneva Convention. And third group of law is are the norms of international maritime law, including the UNCLOS and other conventions that cover the innocent passage and other kinds of passages via international straits, and some standards for relations with navy vessels and foreign flag vessels. That's why these three jurisdictions should be supervised by different international bodies. For example, if we are speaking about violation of prisoners of war, the best idea is to appeal to the International Criminal Court.
Right. But we didn't ratify the Rome Statute yet.
But we accepted the justice and jurisdiction of this court devoted to Crimean issues, as they were captured and being captured in Crimea, not in Russia first time. That's why we should do it and inform the International Criminal Court on these violations, make it by Russian authorities in Crimea, in Ukraine. And the other kind of jurisdiction is to inform and to start the proceeding in the International Tribunal of Maritime Law in Hamburg, asking Russia to release the vessels illegally captured and flying Ukrainian flag. That is another kind of procedure. And third proceeding is really some stages of international human rights bodies like European Court and maybe others. But these three jurisdictions are not common, they're different. For example, if you are combatant, if you are a man of war, other part of conflict have right to kill you. That's why we can't appeal to violation of right of to
prisoners
life.
of war.
And that's why some conflict of this statute objectively exists, and this is not a very simple kind of case. I hope that advocates and human rights defenders in each certain case, for each certain prisoner of war, should develop a strategy, and there will be a common strategy of individual appeal application and interstate claims and information of international cutoff, international criminal court, and of course international tribunal on maritime law. Only complex way of solving this issue may be implemented. From other kind of view, if we are speaking about prisoners of war, party of conflict who keeps them have right to keep them till the end of conflict.
Till the end of the conflict, yes.
That's why Russia may agree, okay, they're prisoners of war and you will be here till we will not sign a peace treaty with Ukraine.
But the thing is that there are some other conditions that these prisoners of war cannot be held in the detention center, they cannot be tried in civil courts, they cannot be put in these prisons together with the regular detainees, which Russians are actually doing. So basically they just try them as regular people, not considering, not recognizing the status of POW.
Yes, and that is a violation of Geneva law. Of course, Russia did violate it and does violate it now. But what will be the future of these persons regarding their statute is a huge question, as we understand clearly that only way to release them is international pressure and sanctions, and maybe possible change of them to some persons that are captured during this conflict by Ukrainian forces. And in these conditions, not only legal aid should be implemented.
How do you think? Why the prisoner exchange didn't happen in January?
I think that we have a very few list of persons whom we may propose for changing. And if you supervise the decision of Ukrainian courts regarding, for example, the criminals from Crimea, the persons who collaborated with Russian authorities in Crimea and were captured by Ukrainian Special Service, you will see that the sentences of Ukrainian courts is very weak, and they say about 2 or 3 years of being in prison, but not de facto or not only de jure. The persons are not in the jail, and of course we can't propose them for change. That's why it is the objective reason of impossibility of changes devoted to the Crimea part of conflict.
So there is too little to propose for Russia in this case. I understand. Well, you mentioned that Ukraine would need to file a court case in the International Criminal Court and also in the Court on Maritime Law in Hamburg. But recently, Ukraine has submitted a request to the European Court of Human Rights against Russia, claiming to recognize the arrest of the sailors illegal. So this is another procedure apart from this package of document, right? What impact can it have, and what ECHR decision could we expect here?
Well, I think the case is clear, and the European Court of Human Rights will recognize violations of some norms of European Convention, but it will be not tomorrow or next year. Such proceeding may have a long time, hearings, and 5 or 3 years for first decisions. That is not a very simple way to decide this issue. That's why I think other jurisdictions should be used also. And of course, other cases also will have some influence to this one, especially related to the other seafarers, not Ukrainian Navy personnel, but for example, Ukrainian fishery, who were captured by force by Russia in 2017, and as I know, they passed individual application to the European Court of Human Rights, about 7 or 5, I don't remember exactly. And in these cases also, European Court of Human Rights should research the issue of international humanitarian law, as those fishermen were captured by force by Russia Navy in the territory of conflict. And of course, the issue of international maritime law.
I understand. Well, speaking in general of these persecutions in Crimea, since you were serving as representative of President of Ukraine in Crimea in 2017 and 18, I would like to ask the following question. The head of the Crimean human rights group, Olha Skripnik, said that Russian-backed authorities in occupied Crimea opened 44 new criminal proceedings in 2018, last year, on grounds of political motivation, and we had like 37 political prisoners just from Crimea. Do you believe these numbers to be accurate, at least about these new 44 criminal cases opened, or could there be some cases hidden and we might not have some access to the full information?
As I may suggest, we can't determine clearly how much political prisoners now are in places on freedom in Crimea, because of course Russia did not recognize that the political prisoners and the articles of Criminal Code of Russia illegally used in Crimea may be used for them as for common criminals, and it is sometimes very hard to determine is this criminal proceeding fake or real. That's why the number may change. Of course, some persons were captured, like Crimean Tatars, and we don't know about their previous civil activities, for example. And from other view, other persons with a huge civil background may be arrested for common criminal case. As you know, Mr. Baluch was arrested for illegal storage of weapon, for example.
Yes.
That's absolutely not true, but somebody other may be captured for the same article and we don't know about him.
Yes.
That's why this number is absolutely approximate.
Yeah, and I just want to add one remark that I was speaking only about the last year. There's 37 new political prisoners only throughout the last year, which is, as for me, a huge number of prisoners just on fabricated charges, right? Yes. The last question to conclude the conversation, because unfortunately we ran out of time. Speaking on return of Crimea, Ukrainian lawmaker, leader of Crimean Tatar people, Mustafa Jamilov, said that the next goal in the process of deoccupation of Crimea will be the creation of a platform to restore Ukraine's territorial integrity in accordance with the Budapest Memorandum. But my question is how? Because ever since we have been speaking about Budapest Memorandum, we know that there are 3 signatories, Russia, the United States, and the United Kingdom, and we have been always speaking that no one is adhering to this Budapest Memorandum. How could Ukraine implement this plan of the occupation of Crimea in accordance with the Budapest Memorandum?
Well, As for me, we can't speak now about the common strategy of the occupation. It is too early to speak about it, as we can't make decisions for our partners like Great Britain or USA. They have own policy, and it is very hard to make influence on it, including Crimea issue. And as for me, the very nice idea was to establish a group of friends of the occupation of Crimea that President Petro Poroshenko declared in 2017. Alas, this group was not realized by the Ministry of Foreign Affairs of Ukraine at this moment. And alas, we can say about huge results of making some platforms of the occupation. And alas, we may point that occupational authorities in Crimea and in Moscow spend a lot of money and other sources to establish some counteractions. They name it Group of Friends of Crimea, and they invite politicians and media men and sportsmen in different countries to Crimea. They make some festivals. For example, they made festivals this month in Ankara devoted to the Crimean and Tatar culture, and they make it in Europe. For example, last month, so-called Mayor of Evpatoria, my native town, visited France and have a lot of meetings with French politicians, and some mayors of French towns and cities visited Crimea. In this situation, I think it's too late to speak about some new platforms. I think in this situation, we should start our current everyday work in reality that we have. As in civilized nations, for example, in European Union and USA, so, for example, in post-Soviet countries and countries of third world, as, for example, the huge problem of modern situation is economic integration of Crimea not only to the Russian economy, but also to the economy of the Eurasian Economic Union, yes, including Belarus, Kazakhstan, Kyrgyzstan, Armenia, and others. Right. It's a huge problem, and we are closing eyes on it and speaking about some fake platforms outside of it. I think it's not a productive way.
Mm-hmm. So what could be, just to conclude the conversation, what could be the concrete advice to the Ukrainian parliament for this new year?
To be very certain in Crimea issues, to solve the certain cases, like immediately cancel of the third named law on the free economic zone of Crimea. It should be banned immediately, I think. Also some steps to enforce the legal enforcement activities related to the Crimean issues, to put a new level of diplomacy in Crimea issues, held in conferences, seminars and events abroad, and it should be systematically and en masse, but not only some for a year. That is those issues and others, like supervising the issue of Crimea in the electoral programs of candidates to presidents and political parties that are going to Ukrainian parliament, should be a good tool to enforce the attention to the Crimean problematic from Ukrainian society.
Well, thank you so much for your valuable comments. Thank you for being a guest today in our studio.
And thank you.
That was Professor Borys Babin, Chief Research Consultant at the Institute of Legislation of the Verkhovna Rada of Ukraine. Thank you for watching Head to Head. I'm Oles Garjuk. Goodbye.